Okay. Hello, everybody. Hello. Let's bump this up just a little bit. Hello. What is it, Wednesday? Happy Wednesday, everyone. Oh, come on in. Good to see you all. Good to see you all. My ring light's like, I'm not playing around here. Not playing around. Oh, it's good to see you too, Casey. Yeah, it's been kind of a bit of a rough go of it recently, but we're doing okay. That you have to show the indictment to the grand jury, right? Right? Oh my goodness gracious. So, as you probably know by now, many of the attorneys out in the world, especially those of us that have worked in criminal courts, are all just like, what age? What just happened? Hello, Chris. Hello, Just Jay. Yes, I'm glad you can, Mama Weed. I'm trying to do my lives around the same time here in the evenings, if I can go live. So, oh, thank you. Thank you so much. Thank you. All right, it is Wednesday. Okay. Oh, you did? You got an okay, Anita. Oh my gosh, that's great. Oh, I'm so glad. Hello, Olga. Hello. Oh my gosh, I'm glad you could swing by, Chris. This should be fun tonight. But honestly, it's fun for me every night. But, it's more about me than you, I guess. No. Oh, thanks so much. Thanks so much. Yes. So, and I'll probably need to say this a couple of times here, but I have gotten to a point now, everyone, with my hands where I need to have some kind of compression on them to get the tremors to slow down. All right. So you may see some significant tremors tonight in my hands, and just don't worry about it. That's just how it goes. But I do, again, have some assistance here to kind of make them not as bad. So I've been a little bit worried about coming on and with my shaky hands, but I figured, it's time. It's time. So, oh my goodness, yes, Vader. I know. I know. Oh, thanks so much, Willie B. Yeah, it's okay. Oh, we got bubbles. Oh my gosh, Chris, I tell you, I waited and waited. I scrolled through everything. I was like, oh, bubbles. Tonight it's got to be bubbles. Oh, thanks, Boxer Mom. Yeah, it's just compression garments as well. Hey, Mexi, yeah, exactly. It's no big deal, NBD. I had been on some medications for it, and I'm out of the medications, and I'm not going to fly over to see my specialist. So we're going to just make do with what we do. So, yes, yeah, well, I mean, it's just really hard on your body, but it doesn't, I'm not in any pain right now in my hands. So just to make that clear for everyone. Hello, Betharoni. Hello. Good evening, Kaya. Good evening. Welcome in. So tonight, everyone, I think this is really important issue here. I thought we would go through and read what a grand jury is and what they do and what they're not supposed to do. I thought if ever there was a grand jury night, it would be tonight. So it's just a few pages. Federal Rules of Civil Procedure. You prefer those? Okay. Like this one? I got you over here. Oh my goodness. All right, so let me make a sticky note so you all don't get bombarded. But it's just one rule here, Rule 6, that we'll go through and kind of talk about it. And I figure we can kind of do a Q&A on what's okay and what's not okay. That's the one. Yeah, I know. Oh, Vader's having PTSD. You have a final next month. Oh my gosh, you'll do great. All right, so here we go. We're gonna do grand jury overview, refresher, grand jury. What should we call it? Let's see, grand jury. Let me see. How about just 101? We'll just do 101. Procedural rules. Oh, okay. Thanks, VC. If you want to get all, that's what I was saying, Brandon. All right. So we'll do grand jury 101. And then, of course, we will put our subcategory of procedural rules because that sounded really good. Procedural rules for federal court. So again, each of our states have their own set of rules for criminal procedure. These are for the feds. So that's what I'll be going through. Procedural rules for grand jury. There we go. Here. Oh, thanks. Thank you so much. Yes, fancy, super fancy tonight. All right, so procedural rules for grand jury, and of course, we're going to put in here for federal court. So, yeah, we've been having some troubles here with the competency, which, that's important to be competent if you're an attorney. That's like in the ethics rules. If you can't, and I know I've told you all this so many times, you could probably teach it. But if you're not competent to do the job that you've been asked to do, ethically, you have to either come up to speed on it and teach it to yourself, make sure you've got it sorted out, or you need to just tell them, I can't do it, and have somebody else assigned. So it is unethical. It is unethical to take a case or go forward on a case or agree to do a case, even if it's the government, even if it's, the president asking you personally. If you're not competent, you're not competent. It's just that simple. All right. Seems like that should be baseline. I agree. Should have passed the bar. Oh, did she not pass the bar? Oh, that's interesting. Yes, it will. Ryland, sorry, I missed your name. Yes, I will be putting this up over on the tube of you. I think I just put the ethics complaint up today. I think that was today. So we're getting there. Girl in her brushes, welcome. She's in a lot of trouble. Yeah. Right, you don't know or you're throwing the game? Ooh, good question. And I would say truly she did not know. I would say she did not know because there are other easier ways, and I'm not going to say because they'll probably use it, but there are other ways that you could, come in and kind of mess things up that didn't involve losing your law license. You got notified. Okay. Well, yeah, I mean, everything should be put on the table now. We're brainstorming everything. There's nothing that's off the table these days. Do whatever she wanted. Well, and clearly she had no idea what she was doing. I mean, just clearly. And that's the thing, though. I mean, as attorneys, we don't really, quote unquote, get a degree or specialize in a particular area of the law. If we start working on an area of the law, then we just kind of get known for that. We can, if we meet the ethical rules, we can say, well, we do criminal law or constitutional law. In my state, you have to go through a whole bunch of stuff in order to be officially, doing one particular kind of law or another. So it's just very, very open on ethics. But the difference between civil and criminal is just, it's a fundamental difference. So sometimes we've got overlap, but we didn't hear. There's no overlap here. This is a mess. I had no idea what she was doing. Yeah, and that's what I hear. So again, I mean, if you're going to go take a leap of faith because you're like, oh, I got a friend in trouble and they want me to do this case, and then you go and you take a look at the case and you see it's like the biggest loss or the biggest criminal case in the country. If you're talking about indicting the former FBI person, right? I mean, it's like, make an assessment. Maybe you could suggest some friends that are a bit better with the criminal law. Oh my gosh. Oh my goodness. I wish I could feel bad, but I don't because that's just how it works here. So, right. All right, well, let's go ahead and dive in then. Rule 6, everyone. We are going through the Federal Rules of Criminal Procedure. This is 2025 edition. Now, you can get this. I'm not sponsoring. What? They're not sponsoring me. What's the other word? I'm not trying to sell anything here. This is what I use because it's easy for me to use this. But you can get all of the rules of criminal procedure for the federal government online. They're all there. And if you want to print them out, great. If you don't have to, but those are all there. So for me, I prefer to have everything, all of my rules and such in kind of a mini form. That's just what works for me. And I'll even show you my Black's Law Dictionary. So this is my Black's Law Dictionary. It's so small. So here's my hand. Maybe there's my hand. See that? That's perfect size for the Black Law Dictionary. Oh, so I do prefer to have kind of a mini thing that I can just work off of. Right. Oh my gosh, I know. Oh, it's such a mess. It's a mess, everybody. It's a mess. All right, here we go. So let's get started. Federal rules of criminal procedure. So Title III, the grand jury, the indictment, and the information. So yes, very portable. Exactly. So the grand jury, we're just going to write all over this because it's mine, and that's fine. Number one, we're going to talk about a grand jury. Now, grand jury is something that is in the Constitution. Let's just take a peek real quick of where it's at in the Constitution, where we've got grand juries. All right, here we go. No, over here. Let's see. All right. All criminal prosecutions, the accused shall enjoy the right to a speedy public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with witnesses. There we go, over here. Against him, to have compulsory process for obtaining witnesses in his favor, so those would be affidavits, and to have the assistance of counsel for defense. All right, so that's the Sixth Amendment. But if we back up a little bit here to the Fifth Amendment, Fifth Amendment, again, is a huge piece when we're looking into federal rules and such. So the Fifth Amendment, no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. This is what I want you to pay attention to, because it's in the Constitution. So, if you're screwing around with procedures and you're like, I didn't know what I was supposed to do. I was going to go to a work comp hearing, and, we were going to argue about whether, the shoulder is the whole body or it's just a body part, whatever. No, we're not talking about that. We're talking about a criminal case, and in the Fifth Amendment setting out the right to have a grand jury, right? So we can see already this is a huge deal. All right, so here we go. Infamous crime or otherwise infamous crime here. Capital, of course, means the unalive penalty, unless on a presentment or indictment of a grand jury. So this is really important. In cases arising in the land or naval forces or in the militia, when in actual service, in time of war, and so on, blah, 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 blah. All right, and there's a lot of great stuff in here, like the due process clause for the federal government. What's most important? Grand jury. Now, many of you probably don't realize this, and don't come for me, but the right to a grand jury for a charge is not guaranteed in the states. It's just guaranteed in the federal government. So each state, if they've added that same language to its own constitution, then your grand jury's all over the place. You got them, left, right, and center. But if not, then in your state, what you're going to see are trial informations being filed. Yes, I picked bubbles tonight, VC. Hello. Oh, yeah, blah, blah, blah. You know what I'm saying? That's my special attorney language. Oh my goodness. Yes, thank you so much, everyone, for the gifts. But I tell you, I saw the bubbles and I was like, oh, that's it. That's the one. Basically said she's done. Yeah, I think that's an accurate assessment. I think that's a very accurate assessment. She's done. Her reputation's gone. We don't know what's going to happen to her license, but thanks, Upgrade. Appreciate it. All right, here we go. Diving in. Rule 6, the grand jury. And then we'll also talk about the indictment and the information, because those are a couple of different things. Summoning a grand jury. First of all, and this is like, oh, I do love the bubbles. Oh my gosh. Man, there's so many squirrels. Sorry, everyone. Back, get back. I'm like, what? The bubbles are out. All right. Sorry. Number one, in general, when the public interest so requires, the court must order that one or more grand juries be summoned. A grand jury must have 16 to 23 members, and the court must order that enough legally qualified persons be summoned to meet this requirement. That's just in general. Alternate jurors. When a grand jury is selected, the court may also select alternate jurors. Alternate jurors must have the same qualifications and be selected in the same manner as any other juror. Alternate jurors replace jurors in the same sequence in which the alternates were selected. So even, oh, thanks again for the bubbles, everybody. So even if, they wanted to do a certain order of who comes in next, they can't. They've got to follow the rules here. So they're even saying we have a specific rule of who even goes in as an alternate. So, and I don't know, for any of you that have, let me ask the chat this. Has anyone in the chat, have you served on a jury? And then my second part would be, if you did serve on a jury, were you a regular juror or were you an alternate juror? I think, let me just ask that so I can get some idea. Kind of out here in my state, we do things a little bit differently. Yeah, I don't know, Willie B. I don't know. Everyone tried to say rural Chris was selected, never served. Okay, well, good for you going in. Charlie, okay, selected both. All right. So both. You were a regular and also an alternate. Excuse because, oh, well, that's all right, Michael. If that's, a request that you wanted to make, go for it. All right, served on a jury, served local city as a regular. Okay. Regular jury, 4-1. Oh, there you go. Cheese and mimosas. All right, that sounds fun. Educating your peers about nullification, never a juror. All right. Yeah, nullification. Alternate on a grand jury. Okay. Texas. Oh, my goodness. Walk, Mom. That's a lot. Selected, was sick, right? They have 3 alternates. Okay, good. Yeah, they never chose you. Oh, no. Oh, well, paralegal. I mean, yeah, you could probably help explain the law, actually. And a victim. Oh, dear. Yes, we don't like to see that ever. Judges try, or at least I hope they still try. If you have a question about that, of a prior harm that was done to you, and they're asking questions as a juror, a potential juror, you can ask to see the judge privately. And so the judge will bring the attorneys for each side back into chambers. And if you're comfortable, you can kind of talk to the judge that way. And then the decision will be made to either let you go or not. Or saying, well, do you think you can still be fair and impartial? And you're like, yes. And so the judge is like, all right, well, whatever. So never ask, oh, they never chose you. Yeah, okay. Thank you for your... Yes, that's right. Oh, I'm so grateful. We couldn't do it without our juries, of course. That's the other part, too, that, and I was talking about this a little bit the other day when I was going through her ethics violation that absolutely is horrible, is, we're taught defense attorneys and prosecutors, both sides, about respecting the juries. They are the most important people there. They are the fact finders. They're the ones that are going to find the truth. And you just have to be so respectful of that and not interfere with that in any way. So the kind of things that have been coming out about what happened on Comey's grand jury, that situation is already like, that's a huge red flag cross, X over. That's a huge violation of ethics. Yes, thank you, all the jurors. Was there an attorney in the juror, Miss Orange, New York criminal trial? I think there was, Willie B. Good question. I think there was. I wonder if there were actually 2. There might have been 2, come to think of it. Okay, yeah. They have to respect humans first. True story, right? Oh, thank you so much. So, yeah, the alternates need to get set out. So, of course, if we need alternates, then so be it. But that's set out here. where we've got our general and then our alternate jurors, which will come in and replace any if they need to be replaced. All right, so here's the first one. Next one, objection to the grand jury or to a grand juror. So this process, again, we haven't even gotten the full jury in yet. Number one, challenges. Either the government or a defendant may challenge the grand jury on the grounds that it was not lawfully drawn, summoned, or selected, and may challenge an individual juror on the ground that the juror is not legally qualified. Right. Unsure about whether or not she'll keep her license. That's kind of like the harshest punishment. You know, I think Giuliani referred to it. Maybe it was Giuliani. I can't even tell anymore. Eastman's so angry all the time. He and Giuliani get mixed up. But it's basically the equivalent of capital punishment for an attorney is to lose your license. So that would be a pretty big deal. But it's possible. It's all on the table. But when we're down here and we're saying the defendant, oh, thank you so much. The defendant can challenge the grand jury because they're saying it was unlawfully done and such. This is where we're at, right, with Comey. This is where we're at right here because Comey is saying, look, dude, the jury wasn't done properly for a whole bunch of reasons. And the judge also said, you are right. She didn't do that correctly. Would she be able to represent anyone else? That's a good question. I don't know. If she does keep her license, she will have to kind of go off into, some place where people don't know her name, kind of rebuild her reputation, and then come back if she wants to. Right, all kinds of things. Exactly. So right here, this is the rule that he's using. Next up, then, the next rule here. Hello, Kelly. Hello. Good to see you. Yes. Will the next indictment get thrown out? Unsure at this point. I would say with the information that I know from what I've heard, it looks as though, well, in reading the court order, it looks as though, the indictment may very well get tossed. All right. So next up, squirrels. We have a motion to dismiss an indictment. A party may move to dismiss the indictment based on an objection to the grand jury, right? So we've got that for sure. Or on an individual juror's lack of legal qualification, unless the court has previously ruled on the same objection made under Rule 6B1. The motion to dismiss is governed by 28 U.S. Code Section 1867E. The court must not dismiss the indictment on the ground that a grand juror was not legally qualified if the record shows that at least 12 qualified jurors concerned concurred in the indictment. And that's something that's unique to our grand juries as well. All right, so let's walk through this. It just means a lot of times when we're going through the process, when we're pulling a jury out, we're going to ask some questions. And as we go through that process, we might learn some information. And the thing, though, that you have to remember is that it's the government bringing this case, right? And almost always the grand juries will come back with an indictment. That's where we got the phrase, you can indict a ham sandwich. But there are cases there's no case like this, but there are situations where something went wrong with the jury. That's what we're looking at here. Now, again, in this rule, I would say, too, another thing to kind of note here is they were running against the clock. They're running against the statute of limitations because the alleged offense took place so many years ago. And so they had to run in order to keep the statute of limitations off the table. But now, if they've got a bad indictment and it gets dismissed, which I think it will, the statute of limitations has run, so they will not be able to refile. So they could say, dismissed with prejudice or without prejudice. It's not going to matter because the statute of limitations, again, has run. The only thing that can toll the statute of limitations is if you file something, right, before it's supposed to be done. All right. Oh, thanks so much, Francois. All right, next up. foreperson and deputy foreperson. So the court will appoint one juror as the foreperson and another as the deputy foreperson. In the foreperson's absence, the deputy foreperson will act as the foreperson. The foreperson may administer oaths and affirmations and will sign all indictments. That's important. All right. So whomever signs the indictment is a juror, right? So the foreperson, so they come in and sign it. The foreperson or another juror designated by the foreperson will record the number of jurors concurring in every indictment and will file the record with the clerk. I think it's important to know who files the record with the clerk, right? The foreperson does. All right, that's their job. But the record may not be made public unless the court so orders it. So we try to insulate our jurors so much just so that they're not persuaded one way or the other. That's the goal. You might say, well, you really want to win your side, so who cares how the jurors go? And I can see why people would say that with some of the attorneys out there right now in the DOJ. But for the rest of us, we want to win, but we want a clean game. So I don't want to play a game that's all, cheating and throwing up problems that aren't really there. So, you have a good, clean fight. Whoever wins, wins. Whoever loses, loses. And you pick up and you go forward from there. But there should not be any cheating on the table because that's not honorable. All right. So we got that foreperson. Now, next, who may be present? Number one. While the grand jury is in session, the following persons may be present while the grand jury is in session. All right. Attorneys for the government, yes. The witness being questioned, yes. Interpreters when needed, all right. And a court reporter or an operator of a recording device. Oh my goodness, everybody. Okay, that's funny. Recording device. All right. So court reporter needs to be there, or there needs to be something recording what's going on. All right. So they might say, well, the court reporter, whatever, wasn't here. And then the next question is, all right, well, get the recording out then. Right. So you can even double it up. And a lot of times that's a great way to do it as well. But, those are two roads. You've got to somehow have a literal recording or transcript of the words everyone is saying. So I laugh at this because, years and years ago, I was a assistant county attorney in this little teeny tiny place in my state. And it was so funny to me that there was this 1980s boombox situation going on in the lower courts. And I was like, what's that here for? And it's because they used cassettes. They actually used cassettes to record the hearings and the little trials. He would record it on a cassette and then he'd take it out and he'd label it like such and such. I'm like, wow. So, hello, Paco Taco. Oh, thank you for the gifts. I appreciate that. How long do they have to keep the recordings on hearings? Good question. Good question. I would say 10 years, but I would not say I've got a statute to back that up. But yeah, the old school days, heck yeah. So then you can just say, whoops, I forgot to turn the tape on. No, don't do that. But the point is, you need to have some kind of a record. And if you don't, then it's like, well, why are you screwing around here? I agree. Oh my gosh, I agree. Kel, absolutely. Oh my gosh, it's so frustrating. Now, again, this is my moment when I say, anyone who is interested in knowing more about the Constitution and how things work, I've got Brino here. Brino DC. That's probably not quite right. He does great work talking about Constitution, the whole process, civics itself. And then, of course, we have Mr. Mayo. Oh, my gosh. I'm going to need help again, VC. And my other friends, VC is always 2 letters is the quickest one. Any of my other mods as well, if you could remind me, it's Mr. Mayo. He is just starting out going through the process. Yes, the morning updates, right? Right. Thank you, VC. Yes, Brino, DC. Um, so with the nothing wrong with cassettes, I agree. I agree wholeheartedly. And also, it can be kind of tricky because then, all right, everybody, I'm gonna say something. I probably shouldn't say it, but I'm gonna say it. The Gen Zs are gonna really struggle with it. That's why it's so fun. Hey, World's Strongest Mayo. Hey, hey, hey. Good. Welcome in. So, as I was saying, Mr. Mayo has a great constitutional law series that he's going through and lots of different questions. So, for those that are like, well, we need to know kind of what's going on, both of these fellas are pretty gosh darn good. So, well, thanks for coming by, Mr. Mayo. Always good to see you. All right, back in it to win it, everyone. Putting the squirrels away, squirrels to the side. Next, we have, again, we've got to have a recording during deliberations, which again was another question in this case, and voting. No person other than the jurors and any interpreter needed to assist a hearing impaired or speech impaired juror may be present while the grand jury is deliberating or voting. So that's important to really remember. No one else is supposed to be there. Next, recording and disclosing the proceedings. So we're literally walking through every single rule here that was violated. Okay. Number 1, recording the proceedings, except while the grand jury is in deliberations or voting. All procedures must be recorded by a court reporter or by a suitable recording device, like a cassette player from the 80s. But the validity of a prosecution is not affected by the unintentional failure to make a recording. So they're saying, well, maybe you forgot or something happened that went weird with the stenographer. Like, why do we lose time? Like, okay, it was good faith belief. So then you might think, well, the whole thing gets tossed. Not true, not true. The validity of a prosecution, so whether or not the prosecution's valid or not, that question is not going to be determined by someone just forgetting to or doing something to make it so it wasn't recorded. All right, so the words are really important here. Unless the court orders otherwise, an attorney for the government will retain control of the recording, the reporter's notes, and any transcript prepared from those notes. Again, friendly reminder, grand jury is brought in. We only have the government. There's not a defense out there like arguing like we will at trial, but this is how the prosecutor, the government, goes through and sets out all the information, pulls in the witnesses, pulls in the evidence, and asks the jury to find probable cause. They do not ask the jury for beyond a reasonable doubt. That's a trial standard. They're asking for probable cause. So, and I want to take that to segue in real quick to another one of the awfulness that I saw and heard out of the court's decision. There was a piece in there where the government had said, if it's not enough for probable cause, that's okay. That's okay. So she's like, that's okay, because we'll pick up the rest of it at the trial. Rest is at trial. That is just like, that'll knock you out of your chair. It doesn't matter. If you've only been doing, I don't know, maybe 50 cases, you've only got 50 cases under your belt, you're like, all right, this is really cool. You know you can't do this. You cannot do this at all. You cannot, like, you can't say the I word, which is insurance, much less anything else. So I can't even imagine in my head what it would look like for this attorney to say, well, if you can't find the probable cause, which is a pretty low standard here, very, very low standard. If you can't find probable cause, then I just want you to know I've got more coming. Like, you wanted more, you should have brought in more. And sometimes it backfires when you don't. Because you only need probable cause, the prosecutor's like, man, I only need a couple of boxes of stuff, right? And because it's such a low standard of proof. But if you've got all this evidence and you feel like it's not enough, first of all, don't say that to a jury. That's not cool. Not cool. Second of all, oh my gosh, I'm just blown away. And for the other paralegals and attorneys or anyone anyone who helps us in our courts, can you even imagine hearing that? That's so crazy. Well, I'm not sure. I suppose it could be. It could be a bit threatening, but it's completely inappropriate. Oh, yes. Kaya. Yes. Mike. Oh my gosh. We did 2 parts last night. Yes, everybody, check out Kaya there in the comments. Oh my gosh, I had so much fun with Mike. So Mike has a podcast, a more perfect podcast, and he is just so much fun. We had so much fun. We went through the Declaration of Independence, and there's 27 grievances, and each one of those grievances is happening right now with our current leader. So we went through and talked about that. We're like, this one, they said the king did all this stuff. And then we're like, yeah, and then he did this stuff right now. Oh, it's fascinating, fascinating. So, right. Yeah. All right, diving back in, squirrels. Next here, right. So again, we got to make sure it's the validity that's not in question. Unless the court orders otherwise, an attorney for the government will retain control of the recording. That part, I think that trust may be over as well. Number 2, secrecy. No obligation of secrecy may be imposed on any person except in accordance with Rule 6E 2B. All right, that's the rule we're on right here. All right, so this is 6E 2A here, and they're saying the B one. Oh, they're so smart when they put these together. All right, dorking out. Here we go. Unless the rules provide otherwise, the following persons must not disclose a matter occurring before the grand jury. Number 1, a grand juror. Okay, zip it. Number 2, an interpreter. Zip it. 3, a court reporter. And I'll tell you right now, they're so stinking busy, they don't have time to be talking about the trial. All right, I'll tell you that right now. So that one's kind of lower on the list because they're busy. Really? Oh, it's tomorrow. Oh my gosh, I'm so excited. It was so much fun. All right, next 4, an operator of the recording device. So whoever's pushing the button on the cassette. I can't. It's so funny. So the button pusher also may not give any information away. And then a person who transcribes the recorded testimony, right? So we've got someone taking down what they're saying, and then eventually we'll have to go through and transcribe that so it can be taken. Right. All right. So we got a couple more here. Next, an attorney for the government. Right? So don't do that. Or a person whom disclosure is made under Rule 6E 3A 2 or 3. So that's the rule we're looking at right here. But whenever we have a rule, we have to have our exceptions, right? They go hand in hand, everybody. And I think this is one of the things that is so important to remember right now with everything that's going on. We have rules, we have procedures, and then we also have exceptions to all of those. So you got to kind of remember that, right? That would be. Oh my goodness. All right, here we go. Exceptions. Disclosure of a grand jury matter other than the grand jury's deliberations or any grand juror's vote may be made to, number 1, an attorney for the government for use in performing that attorney's duty. So that might be, they may try to use it. They may try to say, grand jury matter was disclosed only to the government attorney, right? I'm picturing in my head when they're like, we're not going to do number 1. We'll do 2 and 3, but not number 1. Maybe that communication somehow they're going to try to argue was okay. I don't know. I'm just shooting this out there and how we could use it. More exceptions every day. True story. True. Any government personnel, including those of a state, subdivision, Indian tribe, or foreign government, that an attorney for the government considers necessary to assist in the performance of that attorney's duty to enforce federal criminal law, or a person authorized by 18 U.S. Code Section 3322. So again, those are the exceptions here to the rule as part 1. Now, a person whose information is disclosed under Rule 6E3A2 may use that information only to assist an attorney for the government in performing that attorney's duty to enforce federal criminal law. An attorney for the government must promptly provide the court that impaneled the grand jury with the names of all persons to whom a disclosure has been made, and must certify that the attorney has advised those persons of their obligation of secrecy under the rule. So I'm wondering, do we think that she made it clear to everyone the level of secrecy that was needed? Do we think? Oh, are you talking about the e-files legislation? And a lot of people are like, pocket veto, no. I think if you dressed up for that at Halloween, like, I would just absolutely go crazy. I would be so impressed by that, but no one else would have any idea what you're talking about. Oh my goodness. Right. Letter C. So I think secrecy was an issue with this, government attorney. C, an attorney for the government may disclose any grand jury matter to another federal grand jury. That's interesting. So you can use it as part of your presentation to a different grand jury. That's interesting. I did not know that. Right, exactly, Joe Cray. Exactly. That was the issue, though, wasn't it? Like, are they going to just, pull up shop here in order to get this done in a bad way? Right. If they're still in session, yes. All right, everyone, exhale. I've been waiting to do that. Here we go. An attorney for the government may disclose any grand jury matter involving foreign intelligence, counterintelligence as defined by 50 U.S. Code Section 401A 3003, or foreign intelligence information as defined by Rule 6E3D3, which, again, is the same rule that we're walking through here. To any federal law enforcement, intelligence, protective, immigration, national defense, or national security official, to assist the official receiving the information in the performance of that official's duty. An attorney for the government may also disclose any grand jury matter involving, within the United States or elsewhere, a threat of attack or other grave hostile acts of a foreign power or its agent, a threat of domestic or international sabotage or terrorism, or clandestine intelligence gathering activities by an intelligence service or network of a foreign power or by its agents, to any appropriate federal, state subdivision, Indian, tribal, or foreign government official for the purposes of preventing or responding to such threats and activities. So basically, if there's like some kind of a emergency going on, and we're under attack, I guess the government attorney can tell some other high up people that there's a grand jury going. I would say that. Oh, absolutely. Oh my gosh, Cal, yes, exactly. Oh, no, not at all, VC. And I think it's going to be really interesting, too, to see how they actually pull the files and put them out into the public. Because this was a nightmare down in Florida, but now that they've got the green light, there we go. All right, so there you go. There's another exception here. And then we'll bump back over here. Yes, Trent, I see that. Yeah, and there you go. Yeah, I'm not sure. The reason I question Pam Bondi is because I'm not sure she understands what evidence is. So that's the big question here. All right, here's the next one. Number 1, any official who receives information under the rule I just read through may use the information only as necessary in the conduct of that person's official duties, subject to any limitations on the unauthorized disclosure of such information. Again, let me remind you here, we're talking about the government disclosing information gained or received through a grand jury to someone else that has a high-level position and the world's on fire. That's what we're talking about here, that disclosure, all right? So any state subdivision, Indian, tribal, or foreign government official who receives information, right, may use that information only in a manner consistent with any guidelines issued by the Attorney General and the Director of National Security. Yeah, no, she's not. Yeah, she's not. she's a little different. She needs more sleep. But that's her own fault. All right, number 2, within a reasonable time after disclosure is made, under Rule 6E3D, an attorney for the government must file under seal a notice when the court is in district where the grand jury convened stating that such information was disclosed and the department's agencies or entities to which the disclosure was made. Number 3, as used in Rule 6E, which we've been going through, the term foreign intelligence information means, means first, information whether or not it concerns the United States person that relates to the ability of the United States to protect against actual or potential attack or other grave hostile acts of a foreign power or its agent, sabotage or international terrorism by a foreign power or its agent, or clandestine intelligence activities by an intelligence service or network of a foreign power or by its agent, or, one more down here, just one. Information whether or not it concerns the United States person with respect to a foreign power, foreign territory that relates to the national defense of the security of the United States or the conduct of a foreign affairs of the United States. All of this here is just saying that grand jury information may be shared if needed in an emergency situation. And then this is the process you can go through. All right, so that's a lot of extra words that seem unneeded, but when you're right in the thick of it, you probably will need it. All right, here we go. Next. E. The court may authorize disclosure at a time and a manner and subject to any other conditions that it directs of a grand jury matter. The courts, now we know that, only the courts here can authorize disclosure. And we're going to look at preliminarily to or in connection with a judicial proceeding, which in this case is this motion to dismiss, right? That's on the floor. So the judge is like, well, the defendant needs all the information in order to go forward arguing that motion to dismiss. Number 2, at the request of the defendant who shows that a ground may exist to dismiss the indictment because of a matter that occurred before the grand jury, right? So you can go through and say, once he sees it, you can say, like, during this period of time and this period of time, some shenanigans were afoot here, right? As long as no one abuses the definition of an emergency. Oh my gosh. That's the winner of the internet today, everybody. True winner. I respect all of you, but let me tell you, that is so stinking true. It's so stinking true. Yep. Oh my goodness gracious. Here we go. Moving forward, E here. So judicial proceeding here or request of the defendant let's back up a little bit and refresh ourselves. The court may authorize disclosure at a time and manner and subject to any other condition it directs of a grand jury matter preliminarily to or in connection again with a judicial proceeding, so he needs it to prep his case, or at the request of the defendant who shows that a ground may exist to dismiss the indictment because of a matter occurring before the grand jury. So again, we're pulling through the information in the grand jury to see if there are legitimate questions here. Number 3, at the request of the government, when sought by a foreign court or prosecutor for use in an official criminal investigation. 4, at the request of the government, if it shows that the matter may disclose a violation of state, Indian, tribal, or foreign criminal law, as long as the disclosure is to an appropriate state subdivision, Indian tribunal, or foreign government official for the purpose of enforcing that law. So we've got kind of like this crime exception too, again, with our grand juries. Hello, Meme NATO. And at the request of the government, it shows that the matter may disclose a violation of military criminal law. Ooh, dear. You don't want that coming down on you. Under the Uniform Code of Military Justice, as long as the disclosure is to an appropriate military official for the purpose of enforcing the law. All right. So, but let me ask a quick side question, everyone. And I'm wondering here. So it says here for an appropriate military official. So would that mean is the president a military official? I'm not sure. Because it says here a military official can be pulled in and say, for the purpose of whatever enforcement of that law that I'm looking at here. But now the question is, if he puts on the hat of a military official, which I'm not, I'm just kind of thinking about it, what would happen there? Isn't he well, I don't know. I know, right? Commander-in-Chief of the Army, true. But, again, we got to watch that language real carefully, because even though he may be commander of the military, doesn't mean he's an officer. And that's one of the things that he argued in the Anderson case. Let's ask his bone spurs. Oh my gosh. Yes, since POTUS as well, could, yeah. I mean, it certainly could be. But, whatever happened, if this ever was to come into play and this question was ever asked, it would be heavily litigated. We'd have the briefs out there. We'd have amicus out there. Everyone would be coming in and trying to clarify military official versus president, right? So at least we would have a fight. It wouldn't just be acknowledged, in my opinion. All right, next, because I know everyone likes to have comforting thoughts. All right, hot cocoa time, everybody. Yeah, Steph, I get you. Yeah, we haven't had any kind of forward movement on any of those that have already been decided, so. President told us to do something illegal, don't do it. Well, right. And that's so true, because there's a difference between, giving an order and you're like, yeah, I don't know if I agree with that. And then giving an order and being like, oh my God, I think that's illegal. I don't think I can do that. There's a difference between those two. And it rests on morality. So each soldier will have to make that choice. And it's a tough one. And they're already in a very difficult profession. So to add this to it, that's a nightmare. Exactly. Order and lawful order are different. Exactly right. It's like, why do we need to stress our military out any more than they're already stressed out? That's my piece. I'm like, stop bugging them. They work hard. Alrighty, ready. So, here we go. Okay, so a pish. I was looking at purpose. A petition to disclose a grand jury matter under Rule 6E, blah, blah, must be filed in the district where the grand jury convened, unless the hearing is ex parte. Right, so ex parte just means only one party is talking to the judge. And it should almost never happen. Ex parte is supposed to be very rare and only in the most exigent of circumstances. All right, but it can happen, but it's just very rare. Unless the hearing's ex parte, as it may be when the government is the petitioner must serve the petition on, and the court must afford a reasonable opportunity to appear and to be heard to 1, an attorney of the government, 2, the parties of the judicial proceeding, and 3, any other person whom the court may designate. Very busy right now. Military calling about illegal. Oh my gosh, Snarky, it's so sad what's happening. Come on, are you kidding me? I guess, and maybe it's because most of my family's military, but when you pull someone aside and give them an order that is just so opposite of, ethical or appropriate meaning, it's like, what? And then what's going to happen to me? Stay for the knowledge. Oh, you're so sweet. Anyway, it's a bummer, and I bet too a lot of JAG attorneys as well as other military attorneys are trying to help them out and to understand where the lines are on that, right? Because if you do something illegal and you say the president told you to, I'm just a soldier, that defense is not going to help you. All right, here we go. If the petition to disclose arises out of a judicial proceeding in another district, the petitioned court must transfer the petition to the other court, unless the petition court can reasonably determine whether disclosure is proper. So this is kind of like a back and forth. You take the case. No, you take it. No, you. If the if the petitioned court decides to transfer, it must send to the transferee court the material sought to be disclosed if feasible and written evaluation of the need for continued grand jury secrecy. The transferee court must afford those persons identified in Rule 6E a reasonable opportunity to appear and be heard. So this really reminds me quite a bit of, we had a lot of filings that came in. Oh, hold on, let me see if I can remember which case it was. It was Florida. I believe it was Florida because we had sealing and unsealing of all of that information. And so there were some questions like, well, we don't need this anymore, so you can unseal it. Or this isn't relevant and so on, so it can be unsealed. Excuse me. Yeah. I don't know. It's, in my humble opinion, my very humble opinion as I get a lozenge, like you don't have to be born here to be an American. So all Americans born here and not born here, like, you know, that's what we do. That's what makes us Americans. So we don't follow the rules if we don't think they're right. And I've always appreciated that. Just don't hurt anybody. If you don't want to follow the rules, fine. Don't hurt anybody about it. Next, we went through this one. Here we go. The sealed indictment. So that's kind of, again, what we're dealing with here. Sealed indictment. The magistrate judge to whom an indictment is returned may direct that the indictment be kept secret until the defendant's in custody or has been released pending trial. The clerk must then seal the indictment, and no person may disclose the indictment's existence except as necessary to issue or execute a warrant or summons. So if we had a sealed indictment, right? Go back here. Oh my gosh, oh my goodness gracious. We had a sealed indictment. So we put the indictment in there. It's supposed to be kept a secret. So they can say it's going to be a secret. So the clerk seals the indictment and no one can see what's in there. So at what point, we've got two indictments going, right? This is where they're getting into trouble, is the timing on it. Because you can't just be like, oh, some typos, clerical mistakes. I think it'd look a lot leaner if we just had 2 counts instead of 3. No, you can't do that. The timing isn't right. Sorry, Apple user, I must be missing your discussion here. Didn't argue for immigrants to have to do labor. They argued for any contractor to have immunity. Yeah, I don't know what you're talking about. Meaning if they're following orders of the government, they have immunity. No, they don't. Right. So, and actually, that was kind of set out in the most recent immunity case regarding Mr. Orange. And so if you're talking with the president and you're dealing with the president regularly, you're going to have, some issues. But if they are following the orders of the government, they have immunity. No, Apple user, they might be able to fight and say they had immunity, but if you do something illegal and it's a violation of someone's constitutional rights, then you're going to get dinged. You can come in and try to use your immunity, but that's not guaranteed. Government against the GEO group. Okay, well, I can write it down. I can write it down here. The liability that you assume when you join the military, that your superior is not going to give you something that is illegal to do, That's a little bit different here than intentionally making a situation that is clearly illegal be done by the soldiers. Yes, thanks, house bells. We got it. We got it. They can't follow unlawful orders. Exactly right, Danielle. No one can. No one who has taken an oath to the Constitution, which separates the military from civilians. There are plenty of us out there that have taken an oath to the Constitution, right? But who knows in your neighborhood who's done it? But if you're in the military, every single person in the military has taken an oath. Oh, really? Okay. Maybe I should do that more, even when the government waives sovereign immunity. Well, we might be getting a little too far into the weeds on that one. But yeah, it's a good question. I think we should always talk about immunity when we're talking about government actors. That's always a good thing to talk about. All right, moving forward, we had the sealed indictment question. Next, we've got closed hearing. Subject to any right to an open hearing in a contempt proceeding. Oh, we're already in contempt. The court must close any hearing to the extent necessary to prevent disclosure of a matter occurring before a grand jury. All right, so if we've got some contempt issues going on here, they're just saying that needs to also be sealed, pushed to the side so that it doesn't get out there. It's a retired Air Force. Yes. Yeah. I mean, don't get me started. There's a lot. There's a lot going on right now in the military. My heart goes out to them. Number 6, sealed records. Records, orders, and subpoenas related to grand jury proceedings must be kept under seal to the extent and as long as necessary to prevent the unauthorized disclosure of a matter occurring before a grand jury. This is it. This is it right here. You have to be so careful. Right. Which case VC are you talking about? I'm just curious. Right. It was argued. What was argued? Oh, okay, VC, I got you. Okay. All right. Right. So it was argued, not decided. Arguments of the... Yeah, that could be an interesting side quest here, but I'm going to keep... Oh, crap, I got the puzzle. Oh, my gosh, everybody. No, not the puzzle. Here we go. Oh, my gosh, we did it. First try, everybody. Oh, thank goodness. All right, back in it to win it. So we've got some issues here. Contempt, knowing violation of Rule 6 or any guidelines jointly issued by the Attorney General and the Director of National Intelligence, not security, under Rule 6 may be punished as a contempt of court. So if they're knowingly violating the rule, they can be held accountable for that. I know, Willie B. Oh my gosh, I have to hold my breath, but if I hold my breath, I'm okay. People are like, what are you talking about? Yeah, I know. All right, here we go. Let's dive into the last few pieces here. Next is the indictment and return. A grand jury may indict only if at least 12 jurors concur. The grand jury or its foreperson or deputy foreperson must return the indictment to a magistrate judge in open court. To avoid unnecessary cost or delay, the magistrate judge may take the return by video teleconference from the court where the grand jury sits. If a complaint or information is pending against the defendant and 12 jurors do not concur in the indictment, the foreperson must promptly and in writing report the lack of concurrence to the magistrate judge. We don't know if any of that stuff happened. Hey, Betharoo. All right, discharging the grand jury. A grand jury must serve until the court discharges them, but it may serve more than 18 months. Oh my gosh. I forget how long grand juries are on call. That's a lot. Only if the court, having determined that an extension is in the public interest, extends the grand jury's service, as extension may be granted for no more than 6 months, except as otherwise provided by statute here. All right, excusing a juror At any time for good cause, the court may excuse a juror either temporarily or permanently. And if permanently, the court may impanel an alternate juror in place of the excused juror. This is probably one of the best examples that I could think of was back with Mr. Orange's criminal trial in New York, right? We went through so much to get an impartial jury. And so the first day of voir dire ended, and I think we had one person. I think everybody else was like, we can't do it, we're too scared, which completely understandable, absolutely understandable. But then finally, that one that they did get, I think, went home, and then the next day was like, I can't do this. So then we were down another juror. So it was quite the process getting enough to seat them for the case. But I thought that was very interesting how we've already seen that really in action. Right, 18 months. Can you imagine? Oh my gosh, I know. It's too much. Sorry, I've got to do a side quest over here for a second, everybody. Yes, hello, Krista. Welcome. We're going through the federal rule of criminal procedure when it comes to grand juries. Just got home. Hey, yeah, we're talking about the grand jury here and what the rules are and stuff. All right, I think I got that sorted out. All right, next up, so we were talking about discharging. Oh my gosh, 18 months. I know, right? And excusing. And then last one, Indian tribe defined. This happens a lot, everybody. I just want to, shine a little bit of a light on this. Because of how our laws were written in the Constitution, along with in the treaties that were signed with the indigenous peoples in the different nations, a lot of times Indian tribe was used as easy language. So a lot of our legal documents or even names of statutes we would see them today, if it was fresh, if it was being passed today, as derogatory and ask people to change it. But unfortunately, we just really have a long history of inappropriate language when it comes to our indigenous folk. And, as I was saying, I was doing the Declaration of Independence last night with Mike, and there's a sentence in there that says, and no protection from the Indian savages. And that's a direct quote from Thomas Jefferson. And it's extremely offensive. And then also that term has been used as well in a couple of different places in the Constitution. So here they're defining it, and they're saying Indian tribe means an Indian tribe recognized by the Secretary of the Interior on a list published in the Federal Register under 25 U.S. Code Section 479A-1. Right. Well, hey, it's Fizzy. There has been a case that's being kicked around right now about that, but it's oh my gosh, grade school or high school, where they have a indigenous-like person with a big head dressing on it, and it. It's offensive. And so there's some questions like, well, we like it and, we're being discriminated against because we want to use it, blah, blah, blah. So that's an interesting road that they're going down. But we have another one of those that's heading up to the Supreme Court. Oh, yes, thank you, Kaya. Right. Well, Krista said the country was built on racism. I suppose. But if you look at the glass half full, we are a nation refusing to let that be our forever plan. So at least there's that, right? We recognize there's problems. We made a lot of problems, but we got to fix them. So that's kind of what we do here. Yeah, for a reason. Exactly. The fact too, here's the other side note before I dive in again. The other side note that I think is very interesting is, however long they had those kinds of mascots or whatever, did they just not listen to any of the indigenous people who were like, that's offensive? Like, how many years did it take for them to actually hear that? And it took some time. It's not because the indigenous peoples weren't talking about it. It was just, they weren't listening. And I think that's something to note here, is that it's not like, well, we're okay with it. It's more of like no one's listening. Right. Well, right, exactly. So, just kind of keep that in mind. Keep that in mind. I know a lot of people too, and I get it. A lot of people are very sensitive about, oh my gosh, there's so much racism, so much atrocity, and I agree, it's awful, and shame, and that should not have happened. It's horrific, but you can't swim in it. You've got to figure out, what do we do so this doesn't happen again? What do we do to tell the victims we see them, we hear them, we're sorry, how can we help? That's what we do. You have to just go in and say, this was wrong, but now let's make it right. Let's see what we need to do about it. That's my soapbox, and I will move forward onto the indictment now. All right, the indictment and the information. When used, a felony is an offense other than a criminal contempt. Contempt must be prosecuted by an indictment if it's punishable, A, by unalive, or B, by imprisonment for more than 1 year. So this is important too, because the category of felony here, because it's also setting out what the requirements would be if you were going to have a counsel, right? So just because you're like, I'm super don't have any money, I need a court-appointed counsel, they're like, so that's not our problem. If you make 5 cents too much in order to have court-appointed counsel, but you still have that entitlement if one of these two factors is present, right? So I think that's important to note. Number 2, misdemeanor. An offense punishable by imprisonment for 1 year or less may be prosecuted in accordance with Rule 58B1. So these are our lesser crimes where you're more going to be in jail. If you're only doing it a year, you're going to be in jail. If you've got more than a year, you're going to be in prison, right? So long-term versus short-term here. Right, so B here, waiving indictment. I don't know about that. An offense punishable by imprisonment for more than 1 year may be prosecuted by information if the defendant in open court, and after being advised of the nature of the charge, this is kind of a weird one here, of the charge of the defendant's rights, waives prosecution by indictment. So I guess, if they do it in open court and they're like, do you really need to have an indictment? And the dude's like, no, we don't. So I guess you could not go forward on that. But they're just making room for if people want to kind of go the fast route. So this will be the fast track here. All right, nature and contents. And this is really important. And again, this is the rest of the rule for tonight, everyone. What we're looking at here, again, are informations and indictments. So in general, the indictment or information, and when they say information, they mean a trial information. It's a specific document, a very specific document. Must be a plain, concise, and definite written definite. Let's use that one, right? Written statement of the essential facts constituting the offense charged and must be signed by an attorney for the government. It need not contain a formal introduction or conclusion. A count may incorporate by reference an allegation made in another count. A count may allege that the means by which the defendant committed the offense are unknown, or that the defendant committed it by one or more specified means. For each crime, the indictment or information must give the official or customary citation of the statute, rule, regulation, or other provision of the law that the defendant is alleged to have violated. For purposes of an indictment referred to in Section 3282 of Title 18, United States Code, for which the identity of the defendant is unknown, and that's a hassle. That's really a hassle. Oh my goodness. It shall be sufficient for the indictment to describe the defendant as an individual whose name is unknown, but who has a particular DNA profile. Oh my goodness. As that term is defined in Section 3282. So this is one of those rules, and I think it's good to just see it. Like, they tell you exactly what they want. Like, you need to do 1, 2, 3, 4, 5 in order for this to be done properly. Like, they're not even playing around. It's in the rule. They wrote it in the rule how they want you to do your filings here. Number 2, citation error. Unless the defendant was misled and thereby prejudiced, either an error in a citation nor a citation's omission is a ground to dismiss the indictment or information or to reverse a conviction. So if there's clerical errors are just, they just are what they are. Next, surplusage. Upon the defendant's motion, the court may strike surplusage from the indictment or information. That just means all that extraneous stuff. I don't know if you've ever noticed this, so I'm going to make a generalization, everyone. But if you know any attorneys, which I'm sure you would, because we all just tell everybody, hi, I'm an attorney. Like, we just don't even keep it to ourselves. But what can happen is you'll ask us the question and we'll go on and on and on. And it'll be like 3 days later and nobody's here. I'm still trying to explain, respondit superior. I'm like, did you get it? Did you get it? And they're like, it's been 3 days. We're done. All of that extraneous rubbish here is what the court could cut out. They're like, dude, we don't need all of that. That's so funny. It's funny because it happens. Great. Well, yes, Lisa. And a lot of people don't know how it works. And, a lot of attorneys don't know either if they're not working in the criminal law piece of it. They just don't know. Right. Spontaneous utterances. Or basically whatever Justice Thomas says ever. No, I'm just kidding. Amending an information. Again, it's trial information. So unless an additional or different offense is charged or a substantial right of the defendant is prejudiced, the court may permit an information to be amended at any time before the verdict or finding. And that's really good. I have had many situations where I have filed to amend the indictment. So either, oh my gosh, probably the one that sticks with me the most is I had a case, I don't want to give too much information away, but it was a multi-level, there were like 5 victims, and it was a high level of assault. All right, so let's leave it at that. And so, I'm putting the case together and talking to the witnesses. I'm talking to the victim. I'm, like, all right, we're going to be going to jury trial here in just a couple of days. And then the copper, oh my gosh. So I called the copper and I was like, dude, I'm going to need you to come and testify on Wednesday. And he's like, well, what for? And I said, well, this case, you're the one that wrote up the case. And he's like, yeah, well, whatever. And I said, well, what do you mean? He's like, well, the guy said he did it. And I said, I'm sorry, you mean the defendant that I'm going into trial against next week? He told you he did the crime? And the copper was like, well, yeah, he did. And I'm like, did you put that in your report? And he's like, you don't get to talk to me that way, blah, blah, blah. And he just crashed out. I had to put the phone down on the desk so I could go and make some copies. And then I came back, he was still screaming. So what happened was I had to go back into that copper's file, pull the confession and submit it. And we had to add in different pieces because we were amending it. Oh my gosh. Well, they do. Some are fantastic, but sometimes they're not. And this fella, the other coppers were like, well, you're part of the team now that you've been chewed out. And I'm like, I'm sorry, I didn't hear what he said. But anyway, yeah, you will find many situations where you need to amend it. You can't just, let's talk about that though. You can't just print out another copy of something like, the indictment and then just be like, okay, sign both of these. We need 2 copies. That is not how that works though. So let's be clear on that. Right. All right. Last in Bill of Particulars. And this was kind of something that for those of you that were with me when we went through Mr. Orange's Georgia case, we had a ton of demurs that were in front of the judge, and it just got ridiculous. And one of the big questions was, why aren't you using a Bill of Particulars instead of all these demurs? And the judge was like, look, we don't have a Bill of Particulars set out like they do at the federal level or in other states. And so, they've got to deal with the demurs. I hope they change that though. That would be definitely a lot cleaner. All right, Bill of Particulars. The court may direct the government to file a Bill of Particulars. The defendant may move for a Bill of Particulars within 14 days after arraignment or at a later time if the court permits. The government may amend the Bill of Particulars subject to such conditions as justice requires. So a bill of particulars, oh my gosh, I had this filed against me so many times when I was a prosecutor because it's just a pain in the butt. It's just a big pain in the butt. So I'm a prosecutor on a case and the defendant's like, we want a bill of particulars. So they file it. And so I have to go in and argue and explain why we don't need a bill of particulars in this situation because everything's already there. There is nothing else. And then the defense being like, oh, that's not true. We want you to set out exactly what you're going to do. Now, a bill of particular forces the prosecutor then to put their whole case there. Your whole case goes out and you are showing all of that information, which is fine, which you should do. But once all that information is out, you're locked into it. Because you've said during your particulars hearing, you're like, okay, well, 1, 2, 3, 4, 5, this is our case. What happens if you find 6 or 7? It's possible to amend it, which is good, but it's a hassle. So the bill of particulars, if you are a prosecutor, that's when you're saying like, well, defense counsel is just being a jerk face. And then for defense counsel, they'll come in and put a bill of particulars in and say, you didn't have probable cause to charge. Why are we even here? So there's validity with both sides. I'm not going to say it's good or bad. I'm just going to say there's two different sides to the coin on that. And I would have to say a bill of particulars for Miss Letitia would be perfect. I have not gone through all the changes that have gone on with the AG out of New York, but I do know there's some interesting questions being pulled, and she would do great asking for this bill of particulars, and also call me as well. So that's the final piece. Demurs. All right, sure. You're saying it better than I am. First of all, let me just say that. Hold on, let me see if I've got, I do have it, okay. Whew, there's new evidence that comes up later. Can you use it? Yes, but it's a hassle because you got to go through this whole process of explaining rather than just showing up in court. It can be quite the hassle because you're basically forcing yourself into your own narrative. I mean, it's not like we're hiding a bunch of stuff. Ooh, don't be afraid, everyone. Don't be afraid. I'm getting into the demurs, okay? We're getting into the demurs. Don't be afraid. But when you put that kind of limitations on what the state's case is going to be, then, there's not much wiggle room anywhere else. And that can be very detrimental because maybe something will come up in trial too, right? Maybe something will open up in trial and now it's like, man, I can't use that. So, all right, this is our favorite filter. We're going to take a couple minutes here because that was the last of the grand jury rules, everyone, just so you know. We went through the grand jury and then we went through trial information and such. Right. You think both cases will be dropped? In my professional opinion, yeah, I thought Miss James' petition did not have probable cause to take it to where they wanted it to go. They just didn't have probable cause. If they've done more research, who knows? But and then Comey's was even lighter. So both of the indictments were very questionable, and it was like one of those moments when you think, well, what were you doing, grand jury? Like, how'd you come back with that? So it's possible. All right. I've scared enough people. So this is the Georgia case, and it has been newly reawoken. It's back. It's like been zombified, but it's back now. All right. The most important thing is that I make myself laugh, everyone. The reason I pull this out, here's the indictment, all right? So we had 41 counts total. We have this RICO situation going on where you had to have two acts, essentially, of racketeering in order to show that the grand plan, the master plan, was going forward, all right? Enough with the racketeering. But what happened was we had 19 defendants. And when this came out, this was a crazy town. This was crazy. And then I went and looked in Georgia and it's like, this is just how they do their RICOs. Their RICOs are crazy. And that's fine. But now that we know, we know. So we had 19 people here. What happened was we had, let me pull this other one over here. Here's the demurs. Oh, probably can't see that. There you go. Here's the still can't see it. There we go. Here's the demurs. So what happens is the defendants came in and they said, you charged this wrong, or the law is not working right, or this law was unconstitutional to even have it. So because their RICO law set up that minimum 5 years prison That was the only case where if the orange fellow was found guilty, he was mandatorily required to head to prison for 5 years. That's just what their law was there. That's no longer that, even though the case is coming back to life again. But the demur, again, is just saying to the judge, the law and the information is incorrect here, and let us tell you why. And then the judge comes back and is saying, okay, I'll grant your demur, so the case is kicked out, or I will deny your demur. So he spent a lot of time working on that. I'm not about, hello, Tiffany. Did you ask for the votes? Yes. Right, exactly. Oh my gosh. And that was what, that phone call itself, the phone call itself actually was charged, but then kicked out because our solicitation of violation of oath by a public officer, all of those charges were kicked out because the judge said, I don't think we've set that out properly. Oh, about Fawny. Oh my gosh, I tell you, I know. When all of this stuff started going down with Miss Fawny Willis, we're like, well, what frustrated me was I could not see any rule that she was violating. There was this appearance of impropriety, but that's like, that's like a catch-all for everything. But she's so incredibly intelligent. She's so intelligent. She's amazing. She's an amazing prosecutor. She's got the weight of the world on her, and she's like, more weight. Let's do this. And I love that. But this situation, it seems like probably no one is more upset with her than she is with herself, So for me, I don't feel angry because I know that this woman is like, that's probably the worst thing I've ever done in my life. That was the worst bad decision I ever made, ever, as opposed to a motion to dismiss. Well, right. So that's a good question. Now let me, real life, I'm sorry, my picture's off here. Why? That's a good question. Why would we do a demur and ask them to kick out the racketeering piece? Because the rest of these are just regular criminal charges, right? So if you wanted these dismissed, you would just file a motion to dismiss them. But the law they were arguing under, saying that it wasn't proper or wasn't being done correctly, was the RICO. So that was only count number 1. That's why it was a demur. It's like, we'll push these out, but the rest need to go forward. She got kicked off the case and he became, well, right. I mean, yeah. She won so many big RICO cases in her career. They had to nitpick something. Well, I agree. And I have to say, with this administration, with these people, they're very like mafioso. They've got long memories, and they are willing to do what they need to do to kind of harm others because they're angry. Not all of them. And in my own opinion, let me just clarify that. But yeah, Georgia was definitely, oh my gosh. Well, and we also had too, lest we forget, we had speedy trial requests too. We had Cheese and Crackers over here requesting a speedy trial. Like, we're gonna, 90 days, we need you to have a full-blown RICO trial ready to go, because here we are. So with that, they're like, what? And then eventually they were able to plead guilty. What got them was they pulled the RICO filing off of the table for them. So they dismissed the RICO case, and then the other individual crimes that they were charged with, they kind of pled guilty to a couple of those to just have the acknowledgement of wrongdoing. They also had to do an apology to the people of Atlanta for, screwing around with their elections. And Ms. Powell's was, of course, awful because I think she might be kind of a jerk. Oh, I know. Oh, it's still the filter. I can't see the filter when I'm looking at it. I'm just like so serious. And another thing, it's like, look at those eyelashes. That's crazy town. Oh my goodness. Well, we got to have something to kind of laugh about, right? Oh, Mr. Lemonade. Yes. Oh, so funny. That's where the Lemon Squad came from, everybody. Let's wrap that. Oh, all right. So anyway, hopefully that answered your question. Again, surplusage would have been the last 15 minutes that I was talking. That would be an example of surplusage. If you were wondering, Oh my gosh. All right, and then I've got one more thing that I kind of had a couple questions on. I was going to ask you all about it real quick. I'm going through, I'm trying to find a chart or good information on the immigration process that we have here, right? So what are the steps? And I've been looking through that. Well, I agree. Were you making him look good? No, I wasn't. No, dear. All right. We got to get that going so I don't have nightmares. All right, so I found a few different charts, everyone. Filter, I know. It's funny every time. Oh my gosh, look at this, my color printer, everybody. Again, I just replaced the toner. Oh my gosh, I didn't even notice that before it came over here. Oh man, that's not too bad. Maybe we'll shake it. So back to business here. Back to business. I was looking at these different ways of going through the process because I don't understand it. I don't understand immigration law. And so, I'd like to. First here, and I'm just kind of showing you some options if you're interested to go forward on them. The first one here is this immigration roadmap. And this was put together by the immigrationroad.com. Now, I think it's a really good chart, everybody, but it was updated 2009. So we don't have anything really up to date, but this is the chart everybody claims is the chart to use. So there's that. Yeah, supply funds. Yeah, well, I was going to say, but don't worry, I did just get some toner. I go through it pretty fast. Oh my gosh, yes. So this is the simpler view of it, all right? And that map here. Oh my gosh, my friends, listen. Oh my gosh, all those people out there that are like, those people who are saying it's no big deal, you just come over, take a citizenship test, and then boom, you're a citizen. That's not how it works. That's not how. Now let me get you a little bit closer here because the writing is so tiny to fit on this sheet here. All right, so this is U.S. legal immigration requirements for immigration abroad intending to immigrate permanently. All right, so then here's our chart, and you can barely even see it. The first category are baseline requirements, refugee program, diversity lottery, family sponsored, religious workers and executives, all other employment based here. Oh, no, I didn't make it. Oh, my gosh, no. I mean, thanks for the person that did make this, but no. That's too much for me. Here, oh, no, I just wrote down who the person was, but now I can't find it. Hold on, let me see if I wrote it down over here. Nope, I forgot. But what I'll do, though, is a post on this, and then I will give you the name of the group that put it together. Maybe it's over here. I thought I just had it. The statutory process here. Yeah, I just don't remember. It might have been the Catholics, actually. It might have been the Catholics. Hold on. I'm trying to trigger my own brain. I think, because I think this group here did this one. And then, okay, I think it was the Catholics. So there's like a Catholic immigrant thing. And I think this is, yes. And I think this was part of it, but can't guarantee it. Justice for Immigrants. Thank you so much. But anyway, you can see how cray this chart is. So when everyone's like, you're going to do all this. No, I mean, this is crazy. But I thought it would be really helpful, I think, for people to understand that. Like if we just took this first box, let me make sure I can see, and you can see here, right? So if we just have baseline requirements and we start here and it says, vaccinated against mumps, measles, rubella, polio, tinnitus, diphtheria, pertussis, which is whooping cough, hemophilia, influenza, and so on. Are you right now vaccinated against that. And that's the last V time. I can't say the V too many times. Do you have those jabs? If yes, then you're in a class A medical condition. If no, then religiously or medically exempt from the vaccinations. And to that you say, no, I'm not. And then we've got a red square here, and the red square says ineligible. So, that's just number one. Number one, do you have, thank you very much. I appreciate that. Oh, BC, yikes. So here you go. Here's a list of things that you've got to have. And if you don't have it, and you don't have a religious or medical excuse, then you're done. You're not going to be able to go further. This isn't legal advice. I'm walking you through a chart here, everybody. But let's say you said yes. So yes to the Class A medical condition. So next we have, are you an addict or an abuser of something? And if you say no, we can move forward. But if you say yes, now you're also ineligible. But let's say you said no. So threatening mental disorder is the question. Do we have that? Yes, we're back here. We're ineligible. Well, what if we said no? Crime of homicide, torture, genocide, or DRUG crimes. And you'll say no, that puts you back up here. But if you say yes, then you don't qualify. Right, coffee. You can take my liberty, but you can't take my caffeine. But if we said no, we don't do that kind of stuff here, then we're over here. Crime of human, DRUG, trafficking, moral turpitude with a sentence here. So crimes of lying, essentially. Oops, I'm not even in the view anymore. I'm like, la, 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 look at us learning. So that's here, and hopefully you'll say, which one do we want to say here? So if you say yes, then you need to put down when that crime was. If you say no, that somehow is taking us to the terrorist box. I don't know. Are they saying you're a terrorist now? I'm not sure here. But then, oh wait, it comes back. Material support for a group? No, we don't like that. Support under duress? Yes, we were. Support waiver approved. Okay, so it's difficult. It's like, I'm trying to think of the board game where you have to go yes, no, maybe Chutes and Ladders. The point is, this immigration stuff's bananas. That's the point. What I was trying to get at here. This is incredibly detailed. As you can see, you can get it too. But they have included in here different kinds of requirements. And again, just basic. Here we've got refugee requirements, diversity lottery requirements, family, sponsored, religious workers, executives, and then all other. This is a huge, chart. What was I thinking of, Willie B? Sorry. Oh yes, I think so. Well, yes, I think sorry could work on that. We could make a deck of cards with all the requirements. I laugh so I don't cry. All right. So, and then the last piece here that I got, that I will be doing a full live on all of these, everyone. So no worries. I'm just kind of giving you a sneak peek here. But we have an immigration statuses chart. And this was put together by the University of Wisconsin-Madison. And this, I'm telling you, this is the one that makes more sense to me than any of the others. Chutes and Ladders could be. I'll have to get my game out and see. I don't, because that's kind of what it is, right? Okay, you have the pokes, good job. But you have an angry disposition. Okay, fine, you're down again. Here we go. We've got a visa waiver program here, B1, B2, J1, H1B, E3, TN01, and permanent residency. So this is extremely helpful to make sure we're in the right category for who we're talking about. So over here on this side, they're setting out where's your country, your immigrant category, intent, purpose of your visit, how long are you allowed to be here, is your salary required, minimum wage requirements, cost to department to file initial petition, cost to employee. So there are all of these steps included depending on which one you have applied for and qualified for. Oh, at least 2 languages. Absolutely. Absolutely, VC. Absolutely. And I barely know how to do it in this language that I'm speaking right now. Texas closing the Civil Rights Commission. Well, I'm not sure. Why don't you DM me? I'm not sure. The only reason why is because we've had several places that have been closing down civil rights pieces in their government. So there's actually a bit of a group of them. So I can't remember them off the top of my head. All right, this was the University of Wisconsin. And then, oh my gosh, everyone, this is so crazy. So, and then there's more. There's a total of 3 pages of those. It's just kind of a quick overview. And then there's this one. And this one just cracks me up. I mean, I can't see it. I didn't realize my ink was so low, but it says, I can't tell what it says. Hold on. Let me see. Okay. What part of legal immigration don't you understand? Which was Mike Flynn and Shikab Dalmia. All right, so let's take a look. This one, to me, is a lot easier to understand. The more pictures, the better for me. So here's the other little chart that we're looking at here. All right, so we have one little dude here. It says opponents of illegal immigration are fond of telling foreigners to get in line before coming to work in America. But what does that line actually look like, and how many years or decades does it take to get through? Try it for yourself. So, let's try it. Should we try it, everyone? Because this is bananas. 10, 15 years in order to go through the process. All right, here's our first question here. Let me look over here quick. Our first question, do you have a family in the U.S.? Yes, you do? Okay. Is your relative a U.S. citizen or lawful permanent resident? And then we'll just go over here. We follow over here. Legal or lawful permanent resident is your family. So great. Are you the spouse or child of a lawful permanent resident? If yes, over here, then we say if you're the child, are you a minor? Then you answer that question. But over here, if you ask the question, are you the spouse or child of a lawful permanent resident, and you say no, you're out. See, he's getting kicked out. So that's kind of how this chart's flowing, is like you walk each step and they say, well, did you do this? Yes, yes, yes. Or did you do that? No. So I thought this was very helpful. Now this, let me give you the citation for this one again. And, to each their own, but I'm better as a visual person here. There we go. Openlawlab.com looks like. And immigration law. Yes. Yeah, the goal is for them to kick you out. Well, I think what I can truly say is how incredibly complicated it is. This is so stinking complicated. And there's so many working parts that, people are kind of dingleberries about it for sure. The end goal, right. So where can I find this chart? Kimber, yes. So you can go to openlawlab.com and it'll be in there. Take your money, then kick you out. Yeah, and then ask you to send money back to them too. I mean, there's no empathy here. One of the comments that I hear quite frequently, actually, when we start to talk about immigration is, oh, okay, well, so why just have everybody go into your house, bring them over the border. I'm like, I don't think you all understand. If you've got some people that came over from Paris and they're like, oh, we really like it here, we want to stay forever. No, we can't, because we don't have proper documentation. So they just let it expire and live as best as they can. I mean, this idea of everyone kind of crawling over in the dark of night, we're a bit more advanced than that these days. Exactly. It's complicated. Did you come here legally or are you an illegally? Well, JD, that's what makes it so complicated, because whether or not you came here legally, you're gonna have to fill this chart out, right? Go through this entire flow chart, every single step here in this flow chart. Let me bump it up a little bit. All right. Okay, so you go through this like 150 steps here, and then at the end of that, you can tell me whether or not you're here legally or not, right? That's the problem. That's the problem. Yes, it's incredibly complicated. And again, I think visuals are one of the best ways to sort it out, to figure out, like, it can't be that hard. It's like, did you have permission? Did you apply for a visa, right? So that's one thing you would want to do before coming into a country, right? How long does it take for you to go through the process of getting a visa, right? And how long does it take to jump through all the hoops? It takes a long time. That's why they need an attorney, exactly. It's not like, and the other thing too, as another quick side note, everyone, for people who are jumping over the fence or going through the river, of which there are some, that's just not the majority by any means. A lot of times, Border Patrol's like, I gotcha, and you need to go back, because a ton of people are sent back almost immediately after they get there. So a lot of that enforcement has already been in place, continues to be in place. And it's like, well, someone can take credit for closing the borders, but it's not the borders where the problems were. If you look at the numbers and acknowledge that the true immigration issue has to do with people overstaying their visas. All right. So I am not going to say people do illegal things, including coming into another country. And if they are, the only way I'm going to be able to know is if you take me through this whole chart. You just walk me through the chart and you tell me where they are illegal. Right. This is, I know. Very expensive. Yes. And it takes forever. It takes forever to do that. And it's difficult. It's a difficult situation. I get there are people in this country that do not want anyone to benefit except for themselves and their own family. And so what they're trying to do is protect their own interests. They're like, well, I don't think anyone should be able to get free groceries. You should go work for it. Why? I mean, the groceries are just going to go bad if we don't give them out. And they're like, we don't care. We'd rather throw them in the trash than help another person that we have decided is not actually a person. Yes, and that's my soapbox for that business. So I was battling it out with these charts, and so I appreciate you all hanging around and letting me kind of go through it with you a little bit. We will see. I will probably do a full live on actually going through the process, but honestly, it's going to take me a little while because I don't understand it myself. Good soapbox. So many just get a green card. Yes, and actually in my other printer, it looks better, but here, these are the paths. This is a different map. It's also immigration. These are the paths to specific green cards. So here's one, here's one, here's one, here's one. So if you want to go down the green card route because nothing else is working, heartbreaking, there are roads for you to go down, but they're difficult and there's a lot to be done. And so it's possible that they may be settling on this so they don't have to deal with the rest of it. Yes, Kaya, that's what I was thinking. Exactly. Tell Rolo, she's got some charts. She needs help with it. Can you help? And he'll be like, sure. Because he's just a great guy. We adore him here. All right, you're welcome. Of course. Thank you, moderators, as well. I will go ahead and get us shut down here for the night. Hoping to be back tomorrow. We'll see. I know there was a lot of stuff that kind of broke through with Comey today, but I tell you what, Legal Dad is like on fire right now with everything that's going on. So for the Comey stuff, for any of the other stuff that's like, hanging in the air that we've been talking about, Legal Dad's all over that. And then again, Brino DC is also all over it. So feel free to check out those posts. I thought they did a really good job. So I was like, man, I'll just have to, oh yeah, I'll just have to kind of let them have that while I go forward on my closet docket. Anyway, enough of that babbling. See you all later. Thanks for coming by. I appreciate all of you. Have a good night, everyone. Thanks, mods.